Welcome to All About Bankruptcy.
Welcome back to Bankruptcy Unlocked, your legal path to relief with Oklahoma bankruptcy attorney Luke Homen. Luke is the founder of Convenient Bankruptcy, where he helps everyday Oklahomans erase debt and move forward with confidence and clarity. I'm Evan Mack, and today we're talking about something most people don't expect when they file, just how many people are actually involved in the bankruptcy case, who are the players, and why do you need the right legal guide to help you navigate it all? This is Who's Who in Bankruptcy, understanding everyone involved in your case. Luke, how you doing, sir?
Doing great. Thanks for having me again.
Awesome. So right off the bat, though, who are the people involved in the criminal cases? Like as far as bankruptcy goes, and just all encompassing, and let the people know at home.
Yeah, bankruptcy is so different. In bankruptcy, we've got creditors, we've got lots of different government figures involved. So let's distinguish that for a moment, like you said, from a criminal case. In a criminal case, it's pretty straightforward. You've got the people versus O.J. Simpson, right?
Mm-hmm.
You've got the government versus somebody who did something wrong, allegedly. And then you've got the judge and the jury. So you've got the prosecution, the defendant, the trial. And in a civil case, think of something like Brown versus the Board of Education. You've got one side, Brown, versus Board of Education, and the two of them fight against each other, and you have a judge, and you probably don't have a jury, but sometimes you do. So that's more of a two-party system, right? One guy fighting against the other guy. Bankruptcy is nothing like that. Bankruptcy is more of a mob scene, right? It's all these different players. And so I want to spend some time today unpacking who are all these different players and how do they all fit together?
And speaking of that, though, who's at the center of a bankruptcy case? And
all right, the center of the bankruptcy case is my client, the debtor. Debtor is a fancy word for saying person who owes debts. All right, so the debtor files the bankruptcy case. If the debtor's name is Joe, the bankruptcy case will be called In Re Joe. So Joe is the center, but then everybody else gets involved and has different levels of involvement and different stakes. But it's this scene where you've got all these different players involved who all want very different things.
So Luke, what's the difference between a Chapter 7 trustee and a Chapter 13 trustee? How does it affect someone's case?
Right, great question. All right, so totally different goals because we're in different chapters of bankruptcy. A Chapter 7 bankruptcy, again, it's the kind of bankruptcy where you go to court and you don't pay any of your debts. So the Chapter 7 trustee's job is to try and see, are there non-protected assets that can be sold to benefit the creditors? And so the Chapter 7 trustee is motivated by trying to see, is there something I can find and sell? So let's think of minerals. Let's think of one time we had a client who had an Italian villa, weird stuff. It's not your home. It's not your car. It's not your clothes. Maybe it's your second car. I've got a case going right now where this person has a classic car from the 1920s.
Wow.
They don't use it to get to work. It doesn't even run, but there's value there. Now, that's going to get sold. The person's debts are still going to go away, and that classic car is not actually going to come close to paying off all their debts. But the Chapter 7 trustee's job is to get that car to the auctioneer, sell it, take those proceeds, and give all those creditors maybe 5 cents on the dollar compared to the debts.
Wow.
Chapter 13 trustee, totally different. They are not actively involved in collecting assets or selling or liquidating. They are handling the monthly payments. So instead, in a Chapter 13, you've got a 13 trustee who may have a staff as big as 25 people. So his staff is involved in processing payments. The debtor, my client, each month makes one payment to the Chapter 13 trustee. Once the trustee gets a court order from the judge, what we call confirming the plan, then the trustee is going to make maybe 50 payments out of my client's one payment. They're going to take that money, distribute it each month to all the creditors pursuant to the order they get from the judge. At the same time, Chapter 13 trustee and Chapter 7 trustee is also a little bit adversarial because they're also trying to see, how much money do you need to get paid in? What are the various assets? So they're not a judge, the trustee, but they are somebody in a position of authority. They've been appointed by the U.S. government. but they're also not a prosecutor. They're somebody with a specific task, which is getting money to creditors, but in very different ways.
Mm. So look, what exactly does the U.S. trustee do, and how are they different from the judge or maybe even a local trustee?
Right. Okay. So at the highest level, the United States Trustee Program is through the Department of Justice, and it operates under Article 1, meaning it's not part of the judiciary system. It's an administrative agency created by Congress and the president, and they are sort of the watchdogs of the bankruptcy system. They are through the Department of Justice, and these are actual government officials. And they are supervising not only the debtors, but they're also supervising the trustees. So they audit the trustees, they look over the shoulder of the trustees, and they make sure that the trustees are doing everything legally and correctly, but they're also looking for abuses of the bankruptcy system. So the easiest way to think of this is, I would say easily 99.5% of people who file bankruptcy are those poor, honest, unfortunate debtors who did nothing wrong except they're broke. But once in a while, you get that bad apple, right? That abuser. And that's one of those reasons why we have the U.S. Trustee Program, is to say, okay, you, sir, are not an honest but unfortunate debtor. Let's investigate. Let's call you out. Let's see if you should even get a bankruptcy discharge. That's one of the things the U.S. Trustee Program is looking at, is let's make sure that everybody in the system is doing what they're supposed to be doing to the best of their abilities.
So speaking of judges, though, do most bankruptcy cases involve court appearances at all, or is it more kind of like the judge and more behind the scenes where you don't have to appear?
Yeah, that's really interesting. So every single bankruptcy is going to have something that's technically called the Section 341 meeting of the creditors. It's based on Section 341 of the code, and that is not involving the judge. That is run by your trustee, your Chapter 7 or your Chapter 13 trustee, and it's a chance for the creditors, we haven't talked about yet, but we will, the creditors to come. It's pretty rare, actually, but the trustee is going to ask questions, and they're not surprises. These are mandatory pre-written questions for the most part. The trustee is going to ask questions of the debtor. It's recorded. It's usually by Zoom, but that's not actually in front of the judge. Most people who file bankruptcy will never actually go in front of a bankruptcy judge and will never actually go in a bankruptcy courtroom. But what happens if there's a dispute? The trustee and the debtor attorney or the debtor don't agree on something. Well, let's take it before the judge. The creditor and the debtor don't agree on something. Let's take it before the judge. Now, that's normally just happens with just the attorneys involved. But the judge is kind of that final backstop in the system for resolving the disputes between all the different parties. But most people who file bankruptcy won't actually ever be in front of the judge. Totally different. Totally different than any other type of case, right? Civil case, criminal case, you're in front of that judge all day. Here, sort of a last resort.
You kind of mentioned creditors, but who are secured creditors? What makes them different from unsecured or maybe priority creditors?
Yeah. So most commonly, your secured creditors are the mortgage holder on your house, if you've got a mortgage, and your car lender. So mortgage notes, for the most part, don't get involved in bankruptcy as often. Where we see the most involvement is the car loan creditors, because oftentimes people who are filing bankruptcy need to surrender their car, or they haven't been making their car payments, or maybe they haven't been providing proof of insurance. And so the car lender has the most to lose. It's a lot easier to lose out on that car if there's an accident, there's not an insurance. The house is still going to be there. There's insurance on the house. It's not walking away. So mortgage creditors can get involved sometimes, but what we see a lot more is vehicle creditors perhaps even show up to the 341 and just say, hey, do you still have insurance on this car? And where is that? How many miles do you have on that car? Now, that doesn't happen in cases where the client's making their payments or the clients just want to surrender the car. But cars nowadays are worth a lot of money. And so that's something that really is more frequent involvement, is the vehicle creditor really just checking in. Do you want to keep this car? You're 4 payments behind. Are you going to catch that up? Now, they can't come take the car without a court order while you're in bankruptcy, but they can certainly call up your attorney and start asking some questions, and you need to have some answers.
So how do secured, unsecured, priority creditors play, different roles in bankruptcy? And how do they, challenge your discharge?
Okay, so unsecured creditors, secured creditors, let's go back to secured for a second.
Yeah.
Secured creditors often aren't going to go try to challenge your discharge. What they really want is either payments, that's what they really want, or if you're not going to make your payments, they want their collateral back. Okay, you don't want to make your car payment? Give me back the car. Unsecured creditors are only going to get paid money in the case if that Chapter 7 trustee finds money and distributes it to the creditors. So think of credit cards, medical bills, all those sorts of everyday debts.
Right.
Those creditors have no reason to do any real work. They're just going to sit back and see, is there money that the trustee is going to get for me? And if so, I'll get some money. And if not, I get nothing. But every once in a while, you've got that motivated unsecured creditor. They're not just a random credit card. They're the guy you defrauded, the guy you stole money. One time I saw a case where it's the guy who burned down your house, right?
Oh my God.
Those unsecured creditors are more motivated to try and deny somebody's discharge if they think the debtor committed fraud or embezzlement or broke some sort of duty, because they're more interested in seeing, okay, well, you owe us a lot of money. I'm probably not going to get paid any of that money because of the bankruptcy. But if I think you committed fraud, now I'm going to make your whole bankruptcy discharge in jeopardy.
So what happens at the meeting of creditors? Who's there and what does the debtor have to do?
The debtor has to show up. That's the number one goal. They show up, they answer the question. Be there. And for the most part, these questions, and again, that 99.5% of cases, these are pre-scripted questions. The U.S. trustee, who we talked about, has a list of mandatory questions that have to be asked. And these aren't hard. What is your name? Did you review everything? Did you sign everything? Did you list all your assets? Did you list all your debts? There's literally about 10 questions, maybe 15, that are going to get asked every single time. And for that 99% of debtors, they're only going to be talking for about 3 minutes. Did you read it? Yes. Did you sign it? Yes. Because all of the information is in the documents that you already worked with your attorney to prepare and submit. And for most people, this 341, it's just going to be simple, straightforward. Every 30 minutes, they get through 6 or 8 cases, and you just talk for 5 minutes, and then you're done. It's a Zoom hearing. Pre-written questions, you know what to expect. Now, let's say you're somebody who's got that Italian villa. Well, they're going to ask you questions about that. You've got somebody who's got that classic car. Okay, is it in good shape? Is it running? Are you exempting it? Maybe there's a couple questions there. And then you've also got that less than 0.5% of cases where the unsecured creditor shows up and says, hey, I've got some questions because I think that you committed fraud. This is not common. But when you do enough cases, we get 1 or 2 of these a year where my client has lied to me. And they really do have 3 skid steers that they didn't disclose. And they really did commit all these things that they didn't tell me. That's rare. But when that happens, those creditors are going to show up and ask questions. But this isn't a deposition. They don't get to go on for hours because the trustee still has to get through maybe 50 cases that day. So the trustee is going to let the creditor ask a couple questions, maybe 5 minutes, maybe more, but it's not going to be a full day of questions, even if there's a crazy creditor out there or, my client's crazy. Not common, but it happens. So yeah, number one tip of filing bankruptcy, don't lie to your attorney. There's nothing worse than lying to your attorney. I can fix a lot of things if you don't lie to me.
Right.
A lot of things.
It's tough. You mentioned before that bankruptcy is a legal process, many checkpoints. What's the risk if someone tries to file without a Luke Homen?
All right. So first risk, let's talk about secured creditors. We want to make you keeping that vehicle, surrendering that vehicle, getting a new vehicle, protecting your home. We want to make that smooth for you. I can intercept and handle a lot of those questions on the front end. without needing a creditor to show up at the hearing and ask questions. If I've got a relationship, and I do, with most of the attorneys in the state, then when that attorney calls me up and says, hey, I don't have that car insurance, and I send it to him ahead of the hearing, well, now your hearing goes easier. If you hire me, we can anticipate the crazy, right? We can plan for it. We can deal with it. But when you go into bankruptcy and you don't know the landmines, you don't know where you could go wrong, well, then your case might go south in a hurry. And another big thing that's tremendously important in bankruptcy is, unlike a civil case or a criminal case, you get to choose the timing of when you file bankruptcy. And that's huge. The timing can change so many things in your bankruptcy. I won't even go to the details, but timing is huge. But if you file your own case and call me later, I can't unring that bell. You've already filed, the damage has already been started, and now we're in damage control, and it doesn't go as well. So get with us way ahead of time. When you know you're going to file bankruptcy, but nobody's garnished you yet, call me, right? Don't wait until the last minute, because then we have less options. We can get you a better result if you start early.
So Luke, what about advice to someone who's feeling overwhelmed by all these things that we talked about, all these different things they have to consider, and they don't know where to start?
Well, call us. That's the best answer. Call us, talk to us. We'll get you some free consultations. We'll get you some free advice. Also, watch our videos. Click around on our website. We got lots of articles. But at the end of the day, articles are general, and everybody's case is different. So that's a starting point, if you're just tipping your toe in the water. But really what you need is to talk to a lawyer. You need to talk to a law firm. You need to get some advice that's customized for you, because every person's situation is different, and you don't want to do something that's going to turn out not to be right because your situation is a little bit different than the one you read about.
Amazing. Luke, thank you, sir.
You're welcome.
Thank you all for listening to Bankruptcy Unlocked with Luke Homen. If you're feeling surrounded by creditors, confused about the process, or unsure who's really involved, you're not alone. Visit convenientbankruptcy.com to schedule a free consultation and get real answers fast. And don't forget to like, subscribe, leave a review if you found this information helpful, and also share it with someone who needs it.
Absolutely.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.